That's your question on the power of attorney. You're better off having a good power of attorney than getting into the conservatorships and the guardianships because you don't have an annual report
Exactly.
with the power of attorney. right?
Exactly. The question is it better to have a power of attorney and not have to go to probate? Usually that's the case. Now, there may be families where the power of attorney holder's not the right person for the job and you want to go to probate to get rid of them because they're using the power of attorney inappropriately or they're not accounting for what they're doing. And you want that supervision of the court. You want annual accounts. You want someone looking at those receipts. You want to make sure the person's bonded. So there's some times when probate's preferable, but usually it's quicker, it's cheaper. If you can have the loved one do the power of attorney while they're competent and have a person that's trustworthy managing things that way, it's usually the better way to go. Okay?
Jerry, if you have power of attorney established, and you've established that with the bank that you have a power of attorney, any written communication with that bank, would you then indicate that under your name somehow?
Yes, excellent question. So you're the agent for someone else.
Right.
Okay, excellent question. You do not want to sign the other person's name. So if it's Terry and I'm acting for Mark, I do not want to sign Mark's name. I want to sign my name and then write in under it, attorney in fact for Mark. Okay? So it's clear I'm not defrauding anybody. I'm not forging Mark's signature, but I'm also not trying to act for Mark without some basis. So I'm saying right underneath my signature, I'm signing as attorney in fact for the person I'm acting for. So then you've completely and honestly disclosed the role you have as stand-in, as proxy, as ghostwriter, however you want to consider it. So excellent question. You don't want to forge that person's name and you want to disclose what capacity you're signing it. Yeah.
That used to have, I mean, I get asked that a lot, should I sign their name at the hospital and here? Was there ever an appropriate time to do that? I mean, did they use, was it?
No, people just don't know that. I mean, the powers of attorney don't come with a lot of instructions, unfortunately. And if mom or dad did it with their attorney and the kids weren't part of the process, they didn't get those questions answered. They didn't get how to do it. The instruction manual doesn't come with it. So no, it shouldn't have been done that way. I mean, if you knew that anyway, and clearly they weren't trying to defraud anybody, but really you should not be signing other folks' names.
It just seems like so many people ask that question that.
Yeah, I'm glad you brought that up. That is a common question. Good, yeah.
What are the advantages and disadvantages of having a trust?
Oh boy, there's a whole nother seminar. The main one is you avoid probate, and not to knock the probate court, but there are expenses that are associated with taking an estate through probate. First is most people don't like to try and do it themselves. First of all, they're grieving. They're in a diminished state usually. Secondly, they don't want to go over there and learn the hard way they did something wrong. So the first expense is usually they hire an attorney. The second expense that makes a lot of my clients run to a trust is what's called an inventory fee. After you open an estate in probate, you have to list all the assets going through probate and put values with them. So you have to show a bank statement for the last statement for the checking account. You've got to show the SEV on the house. You've got to show the last CD statement, whatever. Okay, and that all gets totaled up. And then there's a fee on the total, and it's about 0.5% of that total. Okay? Which, that's not a big percentage. If you're earning that in the bank, you're like, oh gee, this is a pittance. I'm not making anything. But if you're paying it on a $500,000 estate, oh wait a minute. Now we're talking $2,500. That's real money. So a lot of clients will weigh that out and say, oh wait a minute, for $1,200 or $1,500, I can do a trust, move all my assets into the trust instead of moving them through probate at the time of my death. No attorney fees after I'm gone, no inventory fee. The other thing that's nice about trusts, they're private. When you open a probate estate, you take the person's will with you and you put it right in the court's file. So any nosy neighbor, anyone like that can go read that if they're so inclined. A trust, you don't publish that in a public place like a court. It's all done privately. Now in some families, that privacy can be a problem. Again, if you got the wrong guy as trustee and he's not giving information and he's not giving accountings, You may want to go to probate court anyway, so you have the supervision. But normally, people pick the right folks for the job. So if they can do it privately and just have the family involved instead of a probate court, they often prefer that. So that's kind of a quick answer. There's a lot more to it, but I hope it gives you enough of a basis why people pick one over the other.
You mentioned having your assets in your child's name could be a problem in a few different ways. You can put your bank account in the probate, in the trust.
Oh, absolutely.
And then
You
you
should.
don't actually own it when it comes time for Medicaid. Does Medicaid check your trust?
Yes, you still own it. While you're alive, you and your trust are indistinguishable. So if you've got income, it's coming to your social security number, your trust doesn't have a separate number, that type of thing. Which can be the good news or the bad news. The good news is you haven't given up any control in your life, like when you add Junior to the asset and all of a sudden you find out he's got a creditor issue or he's going into bankruptcy. You're still in charge of the trust, so it's still your asset. So Medicaid would still count it as yours.
Oh, Medicaid would, so
Right.
even if you put an annuity in there, Medicaid would still see that it. that you-
Annuities may be different, because some of them pay only so much per month, some of them have a death benefit, so I don't want to get in too deep on specifics, but during your life, your trust is you. It doesn't really shelter assets from creditors or from being considered in a need-based benefit like veterans benefits or Medicaid, okay? That's really not the job of a trust. A trust is to make a smooth transition at your death or disability so other people can then take control of those assets. Okay? I've heard people say, oh, I'm going to defraud my creditors and put it all in the trust. Yeah, well, okay, that's not going to help. It's like tissue paper when a trustee is trying to hide assets from a creditor. It's not much, it's very transparent. However, at death, it's a great, easy, smooth way, all privately done, to get assets that don't have an owner anymore to whoever they're supposed to go to. Okay, yeah, Eileen?
Is there a certain amount of assets that you should consider having a trust for? I mean, is there like a dollar value you should?
Well, there's two different, the question is, of course, what's the break point to have a trust or not? There's two things to consider with a trust. One is a need. If you have a lot of assets and there might be an estate tax issue, then you can say you need a trust, okay? Right now and through 2011, we're not going to have a big problem with estate taxes, but 2011, the limit is going to go down actually from where it is now. And we're going to go backwards in time, and everyone's going to be able to pass $1 million in assets. So if you've got a couple with $2 million in assets, it would be very smart for them to have two trusts so that they can each pass the maximum allowed under law. Okay? Now, there's a whole nother group of people that come to my office and I explain you do not need a trust. And they say, I want a trust. So who am I to say you can't have a Cadillac when a Volkswagen would do? If you want a trust because you like the fact that it's private, because you like the fact that you save the money of a probate proceeding, because you like the fact that it's immediately in effect, so if you're disabled, it's already got provisions for someone to take over. If you just like all that stuff, you can have a trust. You don't have to have a certain dollar amount in your estate to have a trust. Some people say, you know what, I've got a winter home in Florida and a home in Michigan. If I go through probate, I got the whole expense of the Michigan probate, and then my kid's got to open a separate probate proceeding in Florida to probate that house. Now we're talking $5,000, $6,000, whatever it's going to be. For a small fraction of that, I can put them both in one trust and avoid two probates. So do they need a trust? No, but hey, that sounds like a pretty nice advantage of having one. It's a pretty slick way to transfer assets quickly and cheaply. Do a trust. The other nice thing about trust is you pick which state law applies. So if you live in Michigan now, okay, Michigan law is going to apply. Doesn't matter if you move to Arizona, doesn't matter if you live in Florida at the time of your death, you still have said, I want Michigan law, I know what it is, I understand it, I want it. If you're going through probate, it's whatever state you're in at the time of your death, that's whose law applies. You may not have ever investigated what little quirks there are in Arizona or Florida or Colorado or wherever. So a trust lets you have some certainty too, picking whatever law you want, and that's what's going to apply to those assets. regardless of where you live at the time of your death. So there's a big distinction between needing a trust and just wanting them because I like the advantages of it. All right? Yeah.
On that power of attorney again, how long does that last? When does that power?
The power of attorneys expire at someone's death.
Okay.
So if I give a power of attorney, it could be in effect for 50 years. It could be in effect for an hour if I die an hour later. Death ends those. Then you either need to have assets in a trust to be transferred, or they're going to go through probate to be transferred.
Because then the trustee would take over the account if there was a trustee.
If it's in the
there.
trust, if the
And
account's in the
they would take care of
trust.
like creditors and so forth that
Yep.
would be involved.
They would pay the final bills, they'd pay the hospital, funeral, whatever debts were left, mortgage payments, those kinds of things.
Are insurances liable for, to the creditors or not? If someone had an insurance policy and they passed away, could the creditors take any of that money?
Are you asking if a life insurance
Yes.
policy is vulnerable? Usually not, because those usually have a beneficiary on them, and the money goes right from insurance company to beneficiary. It never gets into an estate or a trust. Now, if there's no beneficiaries because they've predeceased or we ran out of them and it goes through probate, then yes, the creditors would have a claim on it. When you open a probate estate, you publish notice in the local legal news, and creditors have 4 months in Michigan to come in and make a claim that that deceased person owed them money before he or she died. Once they make a claim, the probate court is not going to let you close that file until something is done. Either that you've paid it, or you've negotiated a lesser amount if there's a estate that's insolvent, or you settled, or they withdrew it, if you object to it, that type of thing. So once that's in the file, it has to be addressed. So if it did get paid to an estate, a creditor could take a swipe at it. Absolutely. All right? Yeah.
I assume with the power of attorney, the latest and the greatest one supersedes any
Yes.
previous ones?
Excellent question. Usually they have language in there that specifically says this one revokes all previous ones. They usually say that right in there so that the latest and greatest. And I've seen this battle, unfortunately, with unscrupulous children. You know, one trots mom off to his attorney and gets power of attorney where he's the guy who's going to handle it, and then some short time after, daughter takes mom to her attorney and gets a new one where she's going to be in charge. So that battle can go back and forth, and then it's very confusing to banks or whoever have these on file. That's a good time to just end it and go to the probate court and get someone appointed as conservator. Otherwise, you're playing that ping pong game back and forth. Yeah.
If the power of attorney is registered with the township, doesn't that stay as the head one?
Well, they're usually not registered, which is part of the problem. You can always register with the county that you're revoking one. I just did that recently, so it theoretically, we know people don't go to the county and read all those documents that are filed, but in theory, once we recorded it, it put the world on notice that that power of attorney had been revoked. So if that agent was still out there using it, we could then undo anything he or she had done. That was a pretty extreme case where mom and daughter had a falling out. Mom didn't want daughter to have the power of attorney anymore, so the trump card to revoke it was to file with the county that mom was revoking that power of attorney and that daughter had no more power. And then, of course, she walked that copy to the banks where she had accounts and the insurance companies and things like that, so they all knew that she had stripped her daughter of that power. But absolutely, that can be one of the problems. You asked the question, when would you want to go to probate? These are times when maybe the probate court is the better way to go because it puts a real end to those types of ping pong games where one day it's one kid, one day it's the next kid, one day it's this power of attorney, next day it's another one. The court has now spoken. You're not going to do anything else without a court order. Okay. So, yeah.
Who should have copies of your power of attorney?
Oh, excellent question. Who should have copies? Everyone who might need it. So if you've got 3 kids listed, you got the batting order like I suggested, give the first one an original, give the second one's copies, let them know where the original is. Or put it on file, at the bank, or with your financial planner, your accountant, anybody who might be given this to operate under where your kids or whoever's your agent.
A doctor too?
A doctor, oh, absolutely. If you've taken the time to do medical powers of attorney, take it with you the next time you go see your regular physician. Let him or her get a copy in your file. I get calls all the time, and you know what? I don't work Sunday nights when people are at the ER and the family can't find the power of attorney. I come in Monday morning and find the voice message. Terry, is there any chance you have mom or dad's power of attorney? We're at Beaumont. Can you get it over here? Here's their fax number. It's 12 hours later before I get that message. Who knows what trouble that has caused because there was an emergency. I also heard lately, and I wish I probably could dig it up again, there's a service now, of course, internet, there's a service now where you can file your papers with some repository via the internet, and then you get an ID card in your wallet, and 24/7 you can call them, and they will fax the documents anywhere. So if you happen to be at your winter home in Florida, and you didn't carry all your estate planning documents with you down I-75, you can call this number and have your bank receive a copy of the general power, or the hospital get the medical power, or whatever. So I don't have the link right off the tip of my tongue, but if you leave me a note and you want it, I'll dig it up, or you may noodle around online and find it yourself, actually. But I'm sure there's a swipe fee, like everything else, but hey, maybe it's worth it to have it, and your kids know where this card is. They can call the 800 number and have it faxed anywhere they need it. But I'm a big proponent in giving copies, or I have forms I give my clients to fill out where they leave info, their financial info, their medical, their final arrangements, and give the kid the form. So it says, my accountant is so-and-so, my financial planner so-and-so, here's their phone numbers, here's where I keep the key to the safe deposit box, or here's where I hide my records, I've got them in this bottom drawer. Give them the passwords to stuff. That's the other thing now with the internet. I mean, most of us, or a lot of us, do our banking online. We have our checkbook register on the computer. If people can't get into your locked computer, the fact that they have the power of attorney is really diluted, because all the info they need is under a password in your QuickBooks or whatever you use, right? Sometimes you even forget, which password did I use for this software pro? You got the little, a lot of us have a little card hidden somewhere, or it's in the phone book. Got to tell people that. So yeah, leave the breadcrumb trail, as I call it, so people can find it. Yeah.
You're not saying give that personal information to all 6 children.
No, I'm saying have the paperwork filled out, or have it on the computer so that they know where to go to get it if they need it. Maybe the first one in line actually does have the power of attorney. The rest in the batting order at least know where to find info, or who to call, who the financial people are that are going to have this data if they need to find. If they have to recreate something, who do they start with? If they don't live in the same town or the same area, they may have no idea who your CPA is. They don't know where to start to get last year's tax returns, for example. All right? So like I said, if you want more info, there's pink sheets in there. Oh, yeah, one more.
Yeah, the HIPAA,
Yeah.
if they don't have an power of attorney authorization for HIPAA, what should they do?
They should do a new one.
They should do a
They
new
should
one
do a
at
new
the
one.
doctor's office?
They
Or
can
should
if the
they-
doctor's got the form. Absolutely. Just don't have one that's got a big glaring omission in it, which now that we know HIPAA's there, let's not be using old documents that don't have HIPAA. If their
Should
doctor
they
has a form,
Update the doctor's form too?
yes,
And have the power of attorney on file there too?
yes. You do not want to find out when you call and there's an emergency that they won't talk to you because the old power of attorney doesn't give you that right. Okay. So like I said, last one.
Well, you said that a power of attorney that goes into effect on disability is not always received well?
Yep.
What is the choice then?
The power of attorney that's effective immediately, which I know that sounds like a very scary thing, and it's a very powerful document, and it is. You have to pick someone you trust to be the agent under a power of attorney. The bigger concern, though, in my mind is there truly is an emergency. The document you set up to cover that emergency and the person you've appointed cannot act because it's got this disability language in it and it requires 2 doctor's notes. And that's the usual standard. So first of all, the person's got to gather 2 doctor's notes. Let me tell you how hard it is to get a letter from a doctor, even one who just saw the patient, but a lot of times they haven't seen a patient recently. Then after you've traveled around and gotten those 2 letters, you get to the bank, and I'm not gonna pick on any one bank, they all have this, I've seen them all say, you know what, we're just really not comfortable being judge and jury that these are two valid letters from two doctors that really saw this patient. How do we know this isn't your neighbor who just wants to help you get access to mom's money? We're not accepting it. And they don't have to. There's no rule that requires these third parties to accept these powers of attorney. They gotta be comfortable that they're not gonna be caught in the middle later when the other kid comes in and says, you accepted this letter from a doctor? It's so cheesy looking, you can tell it's a fake, why would you accept it? Oh geez. Now we already paid out the money to one kid, and here comes the other kid arguing. You know banks and insurance companies, they're very risk adverse. They do not want to get caught in the middle of something. So they're really picky about powers of attorney. Their thought is, you know what? If you go to court, we're 100% protected. If you want to take a shortcut that compromises us, we're not in. We're not playing part of that role. So, all right. Pink slips if you want more info, if you want the email newsletter, if you've got questions you didn't want to share because they're sensitive, anything else that you just want to let me know, make a note, leave those, and I will either get back with you, put you on the newsletter list, whatever else you need. All right? And thank you.
Thank you.